Lord, approximately 2 weeks ago, a man named Daniel Ellsberg died. Daniel Ellsberg was an American, and he was the American who leaked the 7,000 pages called the Pentagon Papers. He was employed by the Department of Defense, and he breached his duties to the Department of Defense and almost certainly committed a crime of espionage and various else in leaking his papers, these papers, to the New York Times about the Vietnam War. That leak and the disclosure of the Pentagon Papers led to illegal countermeasures by the White House to discredit Mr. Ellsberg, to halt the leaks of government information and attack perceived political Watergate scandal, which led to the disgrace and resignation of President. But some of those leaked documents that was denounced by the government, but the US Supreme Court stood firm and upheld the right to freedom of expression. We know that reason we don't know who it is, and we don't know why they leaked. Just as we don't know on the applicant's own version, they say they don't know why the Mr. Budlender leaked. If it was him, they say they don't know. Well, we don't know why the Gupta person leaked. Whether he'd been wrongfully fired or whether he was having an affair with someone's wife. We have no idea. But what we do know is that those leaks, those unlawful leaks, were published, and they exposed to public light and public scrutiny the extraordinary wrongdoings that were committed by the Gupta family and that led deep into the heart of the government. Now, I'm not suggesting that these cases that I've mentioned are identical to this case. Of course they're not. Every case is different on its facts. But what those cases demonstrate is that the simplistic approach proposed by the applicants, which says, if you steal a document and you give it to the press, then you and the press are guilty of a crime. More we can go and get an order to that effect without even citing you. That is an extraordinary proposition, and it is one that is incredibly damaging in our current democratic state. After all, if they were right, then the Guptas just missed a trick. The moment there was first a mention of the Gupta leaks, they should have run off to court, they should have got a Moti type order, as is the case here, and everything would have been just fine. But they didn't, because the Guptas, either because they didn't think of this approach or because they were advised it was hopeless, didn't adopt that stance. So, my Lord, what I'm going to submit to you today is that today is in fact an easy case. There are going to be difficult cases on the margins, where there is an acute which meets an acute public interest, and the courts are going to have to battle those and determine how the lines and how to balance. But in today's case, the applicants do not even get out of the starting blocks. I'm going to demonstrate to you that on the papers before Judge Holland-Muter, and those are the same papers which matter today because they can't make out a case in reply despite their attempts to do so. On those papers, they haven't even ticked the box for establishing commercial confidentiality, let alone for establishing commercial confidentiality that outweighs the duty of force protection that was established in Bosasa. So, my Lord, in the course of this address, we propose to address the following issues in turn. Firstly, we will address the ex parte issue and demonstrate that the ex parte application was a patent abuse and should never be countenanced. Secondly, we're going to deal with the question of the order to return the documents and explain that for 4 separate reasons that order is not tenable as a matter of law. And finally, we're going to deal with the interdict against publication and make clear that it doesn't even begin to come home on cases that are 20 years old, like MIDI television and the cases that have embraced it. But before turning to those 3 issues, let me make three general points. The first is that, as I will demonstrate to you, our learned friends have both purported to address the ex parte nature of the application, and neither of them have justified it, but I will return them. The second is that whenever our learned friends were pressed or run into trouble in relation to your Lordship's question, they resorted to effectively arguing the counter-application. You had references to discretion, to the limited disclosure regime, to Crown Cork, to the confidentiality affidavit, by which they mean the second confidentiality affidavit, which is filed on the 15th of June. All of this has taken place. So, whenever they run into trouble, they resort to this question of balancing and measurement and discretion and confidentiality for Judge Holmuter, because none of it was part of the founding papers, and I'll demonstrate that to you in a moment. And the third point I would make is that it's clear at times what their real concern is. Their concerns vacillate. Sometimes they say they want to get the documents back so they can identify the leaker. Well, if that's the case, it is patently impermissible. But sometimes they say their concern is not so much about access to the documents, it's to make sure that the publication stops. They want to make sure that there are no stories published. Well, that's honest, but it's not a lawful basis because they haven't come home under MIDI television. So whether you view the case as an attempt to uncover or whether you view the case as an attempt to stop the reliance on the leaks, in either event, their case must fail. But let me turn to the first of my three topics, and that is the ex parte application. We have addressed the ex parte application and the principles which are required to be met in such an application in our heads. We do so at, I'm going to give you a Lordship paragraph references if that's
yes, please.
At paragraphs 55 through to 68 of the heads. I will not read that to your Lordship. Your Lordship knows the law well from the SAA BDFM case and the other cases. But what is important is that your Lordship put to our learned friend Mr. Maleka the question, but can you explain to me why this application had to be brought ex parte? And we listened carefully. And the best we could understand was that the answer was this was very important to his client, and his client wanted to make sure that this stopped. I hope I'm not doing him a disservice, but I couldn't understand any argument that was put up as to why this was genuinely outside the genuinely fell within the ex parte application. And we submit that there is none, and you know that there is none when you read their heads of argument on that point. I'll deal with the ex parte point in their time. And I'd like to briefly take your Lordship there because it really is quite revealing. Excuse me. So they start at 189 and they say that that there's this contention of abuse, and they deny that it's so. And then at 192 through to 190. I'm looking for my learned friend's main heads of argument.
You're citing paragraph now.
I'm citing paragraphs. Yes. I could give your Lordship the page.
No, sorry, I was a bit slow. I'd forgotten you decided to do that. Yes, I've got it now. Thank you.
Thank you, my Lord. So at 189 to 191, there's just an introduction. And I'm doing this because I need to try and do justice to their argument and demonstrate that it's without merit. Then very bare chronology. And then at 202, we finally have something approximating argument, which says, the article ends by stating that our journalists are continuing to work on follow-up articles in the Moti file series, an indication that further articles were being prepared, and the likelihood that Mr. Moti would not be provided with the documents on which those articles would be based, or that the documents would not even be identified. And here comes the argument. All the objective evidence held documents. Well, let me pause there. That is self-evidently not a basis for an ex parte application. The notion of an ex parte application to restrain publication is unknown in our law under a democracy. In fact, you have to give notice, even if it's only 2 hours or 3 hours, and that's why the urgent court on a Friday always used to get the urgent applications before the Sunday Times was going to, because you give short notice, but you give notice. So that is not a proposition which stands. Then we're told, if the respondents had given notice of the application, it is most reasonable to conclude that the further publication would have taken place in the interim. Well, that's not a basis for an ex parte application, because, as I say, you're always entitled to go to court urgently to prevent publication, and you give notice. This aspect was pertinently raised in the founding affidavit as follows. Put differently, there's no reason for amaBhungane to refuse, and it appeared unless the intention was to hide the identity of the documents and use them clandestinely. That's again about further publication. And then at 206, considering the manner in which the stolen documents were initially acquired and are now being concealed from the applicants in the Moti Group, it was reasonable for the applicants to have a real apprehension that if the respondents were to receive notice of this application, the information that they had been provided with would at very least be concealed. With great respect, my lord. What that means is that every time there is a leaked documents case and you write and say, please give them to me, and the other side says no, you can run off to court and get an ex parte order directing the return of those documents, because all documents, you didn't give them to us, therefore we can go ex parte. It is patently inadequate. And it makes no reference to the letter, which I will give your lordship a reference to, but which your lordship has already referred to, which squarely made the point that no ex parte application was justified. That is the letter to the founding papers. It is 0398, and I wish to refer to 2 pages. At 0398, paragraph 4.1, it's said by Weber Wenzel, my attorneys, to the extent that our documentation, not ending there, and then, because it then says, this is apart from anything else because to do so may reveal the identity of confidential sources. So that is a legitimate, well-entrenched basis to refuse to do so. Avusa says so. But then over the page, it says, 4.3, the only access of our client to the materials is via 2 secured servers outside South Africa. So they say we've got access to one of the servers. But beneath that, at paragraph 5, it says, we are concerned that the tone of your letter suggests that our client may be intending to your client may be intending to court application of some sort against our client. Our client is concerned that your client may be inclined to do so on an ex parte basis, which would, in the circumstances, be unlawful. We deny that there is application. But even if there were, in light of the facts set out above, there would be no basis for such applications to proceed ex parte. The ordinary requirements for ex parte applications are not met. Moreover, any relief granted against our client would seriously threaten our client's rights and obligations to freedom of expression and the media, including multiple ongoing investigations into a range of issues. It is therefore essential that our client is heard before any relief is sought, and if any such application is to be launched, our client requires it to be served on ourselves. We trust that you will heed this caution and draw it expressly to the attention of any judge that is approached. Now, why is that point made? Because in that earlier paragraph, 4.3, it is said expressly, in respect of the second server, our client and its employees have no intention to delete or destroy such materials. So you're faced with a situation where my clients respond and say, we're not giving them to you because of confidential sources. And we undertake via our attorneys that we will not delete them or destroy them for a year. And then they say, but what this means is that there is no basis for an ex parte application, and we trust you will heed this caution and draw it expressly to the attention of any judge that is approached. Now, my lord, I've read these papers. This letter was put before the judge, buried in this application. The letter is buried halfway through, plus the confidential affidavit. I can't find anywhere in the affidavit which expressly says we were told to draw this caution to your attention and we hereby do. I can't find anywhere in the heads that says this is what they say. There are references left, right and centre to all sorts of things, and they say they give an undertaking, but the undertaking is not good enough. I would have thought that this should have been front and centre. But to make it worse, They then do not tell, and our learned friend Mr. Stratton has quite properly conceded this, they do not tell the judge about the decision in WasteTech or the decision in Avusa. And when your lordship says implicitly, why is it? Your lordship says, why is it? And your answer is given as the following. It seems, WasteTech is no longer good law because of the Cybercrimes Act. Now, if that is the argument, and the argument is bad, then the proper thing to do Reports, page 406, paragraph 44 to 45. And there what the court says is, lower courts must be careful not only to pick the it's a reference to the founding affidavit, paragraphs 2.5 to 3.5. But we now know that that is false, or more charitably mistaken. Because you will see from the next sentence of the heads that in the third non-confidential if I could read to you, qualified confidentiality the court saying it must be current. Says it must be public knowledge, it must not be public knowledge. Must be of economic value to the person seeking to protect it. The nature of the information is irrelevant if it complies with the requirements stated. Is that when you come to court to say this document is confidential, you must establish the three requirements set out in Alan Foss. Or you must establish that it is truly personal in a different sense. And I'll come to the birth certificates and the rest. But you can't wave your hands across a bench full of 4,000 documents and say, it's all confidential, it's all personal. It doesn't work that way. And the problem is that the founding affidavit failed miserably on this score. Because when you read the founding affidavit, there are two affidavits. There's the big, thick affidavit in which the letter is buried, which says in very broad terms, things are confidential, the broadest, vaguest terms. And then there's the confidential affidavit, which lists the 4,000 documents. But there is no attempt to meaningfully bring those documents, the documents they know about, within this standard. Now, I accept there will be difficult cases again on the margins, where I know Ms. Goodman has taken documents from me, and I don't know precisely what there is, and so I might need to be more vague. But here they give a list of documents, but they don't demonstrate that they are confidential. How do we know that they can demonstrate it? Because there was some suggestion, well, it's too difficult to demonstrate. Well, we know they can try. And we know that from the second confidential affidavit, which is the one filed on 15 June. Because it's that affidavit that our learned friends keep referring to. Every time you hear about a birth certificate or a child's school report or anything like that, that's not a reference to the first affidavit. The document might be there somewhere, but the explanation is in the second confidential affidavit. And that affidavit is too late. It's called the second confidential affidavit, but it's filed with the reply. And you cannot go off to urgent court, get an ex parte order of extraordinary proportion, and later fix up your case and reply, whether you call it a counter application or otherwise. So, with respect, you keep getting told it's unbelievable that the respondents don't at least tender the birth certificates, they don't at least tender the this, they don't tender the that. Well, my lord, if the case had been brought to say, you have the following 10 birth certificates, why they're on a Moti server is a different question, but you have the following 10 birth certificates, they belong to children, they must be disclosed, we might be in a different case. But instead what you have is an absolute failure to make up confidentiality, first time round, an attempt to do so second time round, and my clients say, we were deluged with this, we didn't have a chance to answer, so my clients haven't even answered that confidential affidavit. So now say my client's trying to hold on to child's birth certificate. I mean, with respect, it's not an argument that deserves a serious response. So, where are we, my lord? The Res Vindicatio doesn't apply. End of the order. There's no showing of ownership on their own version now. End of the order. There's no showing of confidentiality. End of the order. So before we even get to the delightful constitutional issues, which I would love to spend all day arguing about, they've got to make out a case. They are the applicants, they are bound by Plascon Evans, they, the applicants, must make out their case. And the applicants have not done so. And let me lastly say on confidentiality before I move to the fourth point, they need to do more than say these documents were confidential. They've got to say they are confidential. That is why the language of Mr. Justice Southwood in the second requirement says they must not be public knowledge and public property. And that is what links to your Lordship's judgment in BDFM versus SAA. They have to say confidentiality existed and it has not been lost. Even though the documents have been disclosed, not just to the press, but to Mr. Lutsky, so they say. That's their case. They must say confidentiality has not been lost. Without that, they get nowhere. So now let me turn to the last point. And the last point is where they want to have the debate, because make no mistake, and you see this from the papers and what Mr. Moti is quoted as saying in the papers, not referring to this morning's affidavit, I'm referring to all the other things he said. This is an attempt to say the media need to behave. He says so in words of one syllable. So that's why we've had so much argument on that score. But when you go there and have a look, we've dealt with this at paragraphs 84 to 93 of the heads. And at 84 to 93 of the heads, we deal with the principles of source confidentiality. I do not need to spend time on it, my lord. If your lordship give me 1 moment. Just the reference. We do not need to spend time on them. Your lordship knows them well. It's your lordship's own judgment in amaBhungane that was endorsed by the Concord in the Rika case. What I need to deal with is this straw man of an argument which is created, which says that what the media's case is that they have the right to make a call on whether that's in the public interest, and that means they are a law unto themselves. Now the argument is half right. The media does assert, and that's what that passage in the affidavit says, the media does assert that it's for the media to determine whether the documents that they are in possession of is in the public interest and whether they should retain them or dispose of them. Of course that's right. But that doesn't mean that they are a law unto themselves. On the contrary, if the media gets it wrong, then they are liable to claims for damages or interdicts or anything else. But what you can't do is say that any time someone who comes and complains about a document, suddenly the court must now engage in a sifting mechanism through 4,000 documents. There is no precedent for that. Certainly not the example which keeps getting given about unfair competition. Because in an unfair competition world, the reason why the court has that special procedure is to make sure that the confidentiality is not lost. It's got nothing to do with the same sorts of considerations that are in this case. So, this is not the media saying they are a law unto themselves. It's the media saying it is their right and duty to make a call on whether a document and its publication is in the public interest, just like it is the media's right and duty to make a call on whether a defamatory allegation should be published or not. No one says that deprives the courts of jurisdiction. It's the media who must make the call, but if they get it wrong, then the consequences are calamitous for them. And that's why we have cases like Bogoshi and all the rest. So, the whole premise is wrong. So we now come to the actual source protection. And we've heard everything from, well, we know who the source is. Well, with respect, my lord, we know who the applicants think the source is. My clients have deliberately and quite properly avoided saying whether it is Mr. Van Niekerk or not. And the suggestion is, well, if it's not Van Niekerk, you should just deny it. But with respect, what kind of game are we playing? That means that every time someone wants to know about a source, you bring an application, so the source is A, B, and C, and if they deny A, B, or don't say anything about B, then you know it's B. It's, with respect, source protection would go out the window. So the argument that somehow it doesn't matter because we all know who the source is without any merit. The second argument, my clients have been at pains to adhere to their ethics and their duties to do so. The second argument that you've heard is to say, well, Mr. Van Niekerk engaged in unlawful conduct. He was not driven by public interest or civic duty. He was not driven by a desire to reveal unlawfulness and criminality. And quote, unquote, we don't know what his motive is. Now, with respect, my lord, I don't know what Mr. Van Niekerk's motive was either. But I can tell your lordship that it was irrelevant. Because whether Mr. Van Niekerk, just like the Gupta leaker, had a good motive or a bad motive, that is not determinative of what is in the public interest. And let me say that that is made clear by an authority that our learned friends put on, and one that our learned friend referred to in his address. If your lordship would have regard to their heads of argument, it's the European Court of Human Rights decision. It's the decision of the European Court of Human Rights. It's at paragraph 155 of their heads. It's the Telegraph Media Nederlands decision.
Yes.
And what it says is, and this is their quote, while it may be true that the public perception of the principle of non-disclosure of sources would suffer no real damage where it was overridden, in circumstances where a source was clearly acting in bad faith, with a harmful purpose, for example, by intentionally fabricating false information. Courts should be slow to assume, in the absence of compelling evidence, that these factors are present in any particular case. In any event, given the multiple interests at play, the court emphasizes that the conduct of the source can never be decisive in determining whether a disclosure order ought to be made, but will merely operate as one, albeit important factor, to be taken into consideration in carrying out the balancing exercise. So this suggestion that the moment Van Niekerk is assumed to be the source, the moment he's acted unlawfully, that somehow taints the respondents, is just a suggestion without any merit. At best for them, it is one factor, but the trouble is that our learned friend Mr. Maleka concedes quite properly that we do not know what his motive is. Well, with respect, if you can't even know what his motive is, how can you possibly say his motive is so ill and foul that it should be attributed to amaBhungane? There may be cases where one knows what the motive is. He's employed by a competitor. The competitor has a desire to leak. Whatever. It's not this case, and you were told that that's the case. The third point that I need to make on the source duty is the repeated reference to the Steel Granada case. Now, we understand why our learned friends wish to refer to that case so repeatedly and enthusiastically as they have. But the problem is that the case, the references to the case, miss a fundamental point. That case was decided in 1981. 15 years later, the European Court decided the fundamental case of Goodwin, which has been referred to 15 years later, the European Court of Human Rights decided Goodwin versus the United Kingdom, which expressly dealt with source protection and really introduced it to European freedom of expression law for the first time. Goodwin is, of course, incited by our various cases, including the Bosasa, and it's been cited all over. And it is indeed, even our learned friends cite Goodwin. But if I could just, thank you. If I could just read to your lordship what was said in Goodwin at paragraphs 44 to 46. This is at 17-672 of case lines. 44. In this respect, it is true, as Lord Donaldson put it, that an injunction would not effectively prevent publication to Tetra's customers or competitors directly by the applicant's journalist source, or the source's source. Unless aware of the identity of the source, Tetra would not be in a position to stop such further dissemination of the contents of the plan, notably by bringing proceedings against him or her for recovery of the missing document, for an injunction against further disclosure of him or her, and compensation of damages. Tetra also had a legitimate reason as a commercial enterprise in unmasking a disloyal employee or collaborator who might have continued access to the premises in order to terminate his or her association with the company. In other words, the European court saying this was a case in which they wanted to know who it was so they could get rid of him or her, because otherwise he would continue leaking. Not this case at all. These are undoubtedly relevant considerations. However, as also recognized by national courts, it will not be sufficient per se for a party seeking disclosure of a source to show merely that he will be unable without disclosure to exercise the legal right or avert the threatened legal wrong. And then the court goes on and says you've got to consider all of the requirements, including the overriding requirement of the public interest. In sum, there was not, in the court's view, a reasonable relationship of proportionality between the legitimate aim pursued by the disclosure order and the means deployed to achieve that aim. The restriction which the disclosure order entailed on the applicant's journalist's exercise of his freedom of expression cannot therefore be regarded as necessary in a democratic society for the protection of Tetra's rights under English law, notwithstanding the margin of appreciation available to national authorities. Accordingly, the court concludes that the order requiring the applicant to reveal his source and the fine imposed on him for having refused to do so gave rise to a violation of his right to freedom of expression. So, Steele versus Grenada is decided in 1981. 15 years later, the British courts follow Steele versus Grenada, only to be overturned by the European Court of Human Rights, even though the margin of appreciation existed on the basis that it wasn't sufficiently protective of the source. So with respect, Steele versus Grenada must be treated with extraordinary caution. And one of the reasons it must be treated with extraordinary caution appeared from the language that our learned friends read. There was language in that case which said one of the terrible ways in which Grenada Television treated the Steele Corporation is that they invited him on the show and they didn't give him a script in advance of what was going to be said on the show. Well, my lord, if it was our law that carte blanche had to give a script every time they invited someone on the show, my attorney, Mr. Milo, would have a heart attack. That is not our law. It has never been our law. And the fact that the court thought that that was an appropriate standard for a responsible journalist suggests that a case decided 35 years ago, 45 years ago, 40 years ago, should not carry great weight with this court. Then we come, and I apologize for the sort of bitsy way of dealing this, but I need to just knock these points and then we can summarize them. Then we come to this contention about Bosasa. And you are told, well, look how wonderfully the Mail and Guardian, Mr. Basson, behaved in Bosasa, because they just discovered the documents and refused to disclose the source. And in this case, there's no disclosure of the documents. My lord, I was in Bosasa versus Basson. That case was not remotely similar to this. It was a defamation action launched years after. And it was in that context that there was a debate about whether to disclose the documents. You can well understand that in those circumstances, the journalists would disclose the documents because, firstly, the time for risk to the story has come and gone. Secondly, presumably, the time for any risk to the source has at least ameliorated. And thirdly, it was felt that it could be done without disclosing the identity of the source. That's why the Bosasa-Basson case was an attempt by Bosasa to compel Mr. Basson to disclose the source. So it is as far removed from this case as possible, where this case the attempt is to try and stop the reporting, disclose the source, etc. Now, my learned friend Mr. Strachan says in response to that, we don't understand what the problem is, because it won't disclose the source. All we want is the documents. But with respect, my lord, we know what happened in this case. The reason that the applicants think they know who the source is because documents were sent by Mr. van Rensburg to the Moti Group for comment. Those documents were then the subject of a metadata analysis by Cianre Investigations, and they concluded on that basis that this is where the documents come from, and therefore we know the source. Now, whether they were right on the point of today's case, but the point is the suggestion that you're just giving us documents, you're not disclosing a source, is patently bad on the facts of this very case. So, my lord, And lastly, our friend Stratton doesn't argue the Protection for Personal Information Act, despite all the repeated references in the papers and the heads. That's unsurprising, because as we pointed out, the media have an exception under the Personal Information Act. And very lastly on this point, we're told, well, Mr. Van Niekerk is not a whistleblower and he's not in witness protection, and therefore it means that the case on source protection is no good. Lord, it is patently irrelevant. It was never our case that source protection was only good because he was a whistleblower or in witness protection. It's never been our case, and it isn't our law. In Bosasa, there was no suggestion of having to bring yourself within the whistleblower protection or witness protection. And similarly in amaBhungane, in the Constitutional Court, the court made clear it was all confidential sources. It didn't limit it. So, my Lord, where are we? We're in a situation where what is asked to be disclosed are documents received by my client from a confidential source. We are in a situation where the order that is sought would require my client to give up documents given to them by Mr. Van Niekerk. How much could be clearer that it's an attempt to reveal the source? We're in a situation where the papers make clear that Mr. Moti's aim in bringing this litigation was partly to reveal the source. Lord, we are nowhere near the difficult case. Even if you assume the re vindicatio applies, even if you assume that there's no showing of ownership, that there was a showing of ownership, even if you assume that there was a showing of confidentiality, we are nowhere near the difficult case. It's an easy case, and on easy and ordinary principles, it is patently bad. I'm sorry, my junior corrects me very helpfully.
Take your time.
It's not that Cianri did the assessment. It was assessed by Mr. Paul O'Sullivan. He was the one who did the assessment, and Cianri did the assessment of what in fact Van Niekerk took. But the point about metadata is correct. So the point is that it was the documents which revealed the metadata, or are said to reveal the metadata. So if I could just correct that. So, my Lord, on the second leg of the case, is there any basis to order the return of the documents? No. There wasn't in front of Mr. Justice Holland Muter, when you understand the principles properly, but there certainly isn't in front of you on these papers. That then leads me to the third leg of the case. And the third leg of the case is the interdict against publication. And I can be very brief on this, my Lord, because the applicant's case waxes and wanes depending on what they think would be of assistance to the relief. Sometimes their case is a privacy case. Sometimes their case is a defamation case. Let me start with the privacy case. If their case is a privacy case, you have private documents, you may not use them. Well, I've already explained why the privacy case doesn't get out of those starting blocks. So that case is plainly bad. But even if the privacy case were good at that level, it's clear that private documents is not a general basis to interdict publication. On the contrary, the Financial Mail versus Sage makes clear that the public interest is critically important. And I'll come back to how you balance in a moment. So if their case is privacy, that's not they can't even start. But even if they could start, they can't end, because the point is public interest matters a great deal. If their case is defamation, they've got an even greater problem, because their case on defamation would have to be, these are the passages which are defamatory. These passages are defamatory of the applicants, not somebody else, the applicants. That's so. 1, they're defamatory. 2, they're defamatory of the applicants. 3, they are unlawfully defamatory of the applicants. In other words, they're false or whatever basis. They don't even get out of the starting blocks. They do not identify the passages. The most that they do is they say that the articles are one-sided. With respect, my Lord, one-sided might be all sorts of things, but it's not an unlawful defamation. They then say, well, we needed to be heard. We had to have a right to respond, and you only offered us excerpts of the document. Our learned friend, Mr. Stratton, compared it to a witness who doesn't get given the document. Lord, the appropriate analogy is different. The appropriate analogy is that you say to the witness, I know you've got a document in your possession. I'm going to give you part of that document. Could you comment on that? That's the analogy. They've got the documents on their own version. But in any event, the right to reply is not that kind of requirement. We've demonstrated it in our heads on the counter application. It is not a requirement of Bagoshi, invariably. It's not even, this duty of make available everything you've got is not even part of our admin law, and we've given you the authorities for that. So the point with respect is just without any merit. And then they say, well, we rely on the press council and the press code, and our learned friend Mr. Maleka pours scorn on the notion that only the press council can enforce that. But he doesn't deal with the judgment we've put up, which is your lordship's judgment, the judgment of your lordship's brother in Matojani jail, recycling and economic development versus MNET, which we've cited in our case. So they've got all sorts of problems with the cause of action. But let me take a step back and let me assume that the cause of action is good in one or more of those respects. They still haven't come home under the requirement for a prior restraint enunciated in MIDI television and repeatedly endorsed by our courts, including in print media. Could I just spend, and I'm almost done, could I spend 1 moment on what MIDI television is about? Because they say this is just a process order. Well, let me tell you what happened in MIDI television. MIDI television was a case in which ETV wanted to broadcast a program which contained interviews with witnesses who were going to be testifying in a criminal trial. Somewhat audacious, one might say. So ETV wanted to run this story about the Baby Jordan case, and they wanted to include interviews with the very people who'd witnessed the murder and who would become witnesses in the criminal trial. And the DPP, perhaps understandably, was outraged and went off to court and said, they wrote to ETV and they said, we want to see a copy of this documentary in advance. Because when we see it in advance, we'll know whether there's a problem. And ETV said, we don't give out our documentaries in advance. This is not the UK in 1981. We don't give out our documentaries in advance. Forget it. And so the DPP goes off to court and gets an order interdicting ETV from broadcasting the documentary, not indefinitely, only until they've given the DPP an advance screening. That's what the High Court held. The SCA in trenchant terms held that that judgment was untenable. It said that you could not require the media to give an advance citing to someone. But more importantly, that even if there was some fundamental issue like the administration of justice at issue, that did not outweigh the public interest in the unfiltered and unfettered flow of news. And it said again and again and again, Judge Nugent saying, the remedy is after the fact. In all but the most extraordinary cases, the remedy is after the fact. Why? Because we don't engage in prior restraints. And exactly the same principle was endorsed in print media. The Con Court expressly endorsed it, saying that you don't give prior restraints except in the most extraordinary circumstances. And Lord, let me assume against myself that there is somehow a cause of action on this leg, either privacy or defamation, or not given a proper right to reply. Nothing that is said makes this case so exceptional that it takes it out of the ETV or the MIDI television case. Nothing. And on that basis alone, the order cannot stand. If they had gone to court and said, if they hadn't sought the prayer about the return of the documents and they just sought an interdict, they would have been laughed out of court. But instead, because they bring in this return of the documents and buttress it and add this, somehow it becomes different. With respect, this case is a non-starter on this leg too. My Lord, I'm now going to turn to costs. Oh, yes. My Lord, my learned friend Ms. Goodman was going to deal with a counter application, but we don't propose to deal with it any further in light of your Lordship's view that it's not a problem.
I don't need to hear that.
Thank you. Our heads are there and they do deal with some helpful points on the matter. So, my Lord, on the question of costs, there are 3 sets of costs. There are the costs before His Lordship Mr. Janssen van Nieuwenhuizen, which were reserved. There are the costs before your Lordship on the main application, and there are the costs before your Lordship on the counter application. We submit that all of them should be paid by the applicants, and they should all be paid by the applicants on an attorney-client scale, including the costs of 2 counsel. Well, Lord, I have never understood whether there is a difference between attorney-client and attorney-owned client. I've been asked to urge you for attorney-owned client. Let me be clear, we ask for the highest scale of costs available, whatever that may be.
Thank you.
But Lord, is there a basis for the order? We say unequivocally there is, and let me tell you why. Firstly, in respect of the ex parte application, it should never have been brought ex parte. And having been brought ex parte, it was not met with full disclosure. On that basis alone, attorney-client costs are warranted. Secondly, in respect of the proceedings before Judge van Nieuwenhuizen, where the parties ended up at Judge van Nieuwenhuizen's rather insistent urging, was they ended up on an order that had been proposed by my clients 24 hours earlier and rejected by the Moti Group. Well, on that basis alone, leaving everything else aside, the costs should be attorney-client costs, because the order was one that would have avoided the urgent court being troubled and would have avoided my clients having to send counsel to the court. But thirdly, and in any event, this, my lord, is the absolute archetypal SLAPP suit. This is an application brought by corporations with deep pockets in an effort to intimidate the media into silence and to make it as difficult as possible for them to do their job. I don't have to tell your lordship about the judgments in Mineral Sands Resources, your lordship is well aware. I don't have to tell your lordship about the judgment in Morn versus Zuma, your lordship is well aware. But those judgments make clear that the right to approach a court under Section 34 of the Constitution is not a right to abuse that process. It says that a court must take steps to prevent abuse, and this is abuse. By asking what litigants have done, if that reasonable litigant wrong, they had a case. Well, the first thing is they wouldn't have gone ex parte. They would have given notice, they would have gone off to court. The second thing is they wouldn't have tried to fix up their case in reply by filing second confidential affidavits, later third confidential affidavits, a counter application, which is patently without merit. But the fourth thing is, in truth, having seen the answering affidavit, they would not have persisted at all. Even if you the first answering affidavit before Van Nieuwenhuizen and AJ came in, and the second answering affidavit before you came in, the second litigant would have beat a hasty retreat. They did not. We are here. They have briefed 8 counsel. It's hard to imagine a more obvious attempt at bullying than this case. I speak not about the legal representatives on the other side. Of course, they are doing their job. I speak about the applicants. And we ask that the court make clear that this bullying is not what our courts are for. You can have a legitimate disagreement with the media, but you don't engage in this kind of conduct. And we would ask your lordship to mulct them in attorney-client or attorney-unclient costs. My lord, we have employed 3 different counsel, but we have engaged in a tag team effort. So we only ask for the costs of 2 counsel. As you will see, my learned friend Mr. Winks is away.
Thank you.
Lord, just to round off the point, just to make absolutely clear, the Cybercrimes Act, I'm not going to get into the weeds on for 2 reasons. A, it wasn't pleaded in the founding papers against my client. B, it doesn't change the case, because the debate about whether Mr. Van Niekerk breached the law in giving my clients the documents doesn't assist. And thirdly, it doesn't change the legal position on the Ray Vindicatio. So we can get into the weeds if you wish, but it seems to me with respect that it just doesn't take it anywhere. But I shouldn't be understood to agree or in any way endorse the submissions now made by my learned friend Mr. Stratton. We submit that they are quite wrong on the interpretation of that act, but urgent court is not the place to decide that for the first time, if it can be avoided.
Thank you.
Thank you.
We'll take a break now. I'm going to suggest we take a 20-minute break now.